So, is an unrecorded deed legal on a property? Hello, this is Dave at TitleSearch.com. In this video, we're going to talk about whether or not a deed that's not recorded on title has effect on the property. First of all, determine the difference between legal and valid. Now, if a deed is recorded between two parties, one is an owner of a property or a seller, the other one's a buyer, if they execute a deed between themselves, it may be legal. It may be a legal deed of transfer, but it may not be valid, meaning that it may not affect the property. What's the difference? Well, something that's legal has the elements of a transfer which are required under that state's laws, and you might want to check with an attorney to make sure you understand the laws of deeds and recordings. But in most states, any real estate transfers have to be done in writing under the statute of frauds. The second thing is it valid? Well, if it's not recorded, the argument could be made that nobody knows about it, so it's not valid on the property. But if a potential buyer or lender or creditor has constructive notice of that deed, meaning they know about the fact that it exists, even if it's not in the land record, or they should know because there's other items which would lead them to it. There have been many cases, and attorneys will back this up, where a deed that's not recorded has had validity on a property against a person because they knew about it. Does that seem unusual? Well, what we're saying is that a property may be affected by a deed if one person is looking at it versus another. If one buyer knows about the existence of a hidden or secret document, the lien, deed, or judgment might be valid against them. But if an unknowing person purchases that property, the deed may not be valid against another person. It seems unusual, but deed validity sometimes is determined by what's called constructive notice, meaning not actual notice that it's in land records, but constructive notice, meaning is there something else which would lead to it. For example, if the borrower, seller, buyer, creditor knows of a debt that's on a property, that might require them to do due diligence to find out more about it. Are they aware of an alternate spelling of a person's name where that deed could be found under that name? Are they aware of a spouse that may have interest in the property? If a buyer or creditor knows these things, they may have constructive notice of this unrecorded deed. How else can an unrecorded deed affect a property? Well, is it recorded later? Is a deed executed today but not brought to the land records for a year? Well, what happens during that year? How did that deed affect the property? If there are other records which have been recorded during that interim time, there may be a question of which has validity. Most states go by what's called a race notice criteria, meaning that whoever gets there first. The word race literally means speed of distance to get to that courthouse with the documents. A good example of this is what's called a silent second mortgage. A lot of times, if there's a purchase of a property and the buyer doesn't have enough money for a down payment, the seller will hold back a second mortgage, but they won't record it right away because they don't want the first mortgage company to know that the down payment money is being borrowed. So they might wait a month or two or three to record that second mortgage. This may be illegal, but that second mortgage could be an unrecorded deed that could have an effect on the property. That's an example of where there may be a delay in recording. Sometimes the delay has to do with ownership transfer after death. Instead of filing a will or some other type of trust agreement, some property owners will say, look, I'm going to give this property to my son. They sign over a deed with the understanding that the son won't record it until after their death. That may be legal, but it may not be valid. There may be other ownership transfers or liens which occur in the meantime which could have priority over that unrecorded deed. The main thing is the person who's contemplating a purchase or interest in the property have knowledge of this other record, or should they have knowledge? And so it brings us back to that a unrecorded record may be valid against some people but not others based on their knowledge. If you want more information about deeds, unrecorded deeds, you can reach us through our website at TitleSearch.com.